Hello to the public. I'd like to regard you. This is a studio of Vision, production of Serbian story, Srpska priča. You will have chance to hear the arguments of Mr. Oliver Like, who is a Swiss human rights lawyer and defender of Alexander Dorin's case since February 2019. This interview will be in English, so I ask you and I'd like you to watch this video because it'll be really full of very important information for all of you, especially in Switzerland. Oliver, you're welcome. Thank you. Thank you to be here. Thank you for being here this evening. This is a very interesting story we are going to talk this evening. First of all, would you be kind to represent yourself? I told some information to our Serbian public, but what's important, how many, for example, cases of infringement of human rights you were faced with, what kind of cases we are talking about, and please represent yourself so the public could know more information about you.
First of all, thank you for the invitation, also on behalf of Mr. Dorin. I'm a Swiss lawyer with my own chamber since February 2014. I mainly work as a criminal defense lawyer and as well in human rights. The majority of my cases are based directly on the articles of the convention, and as well as since I have the mandate from Mr. Dorin, I also started to reprimand the violations which I see in his case.
What can you tell us about Mr. Dorin's case? And what is the situation with human rights protecting and legal system in Switzerland? Could you explain to our public what are national remedies in Switzerland? What's the way of one application?
It depends which kind of proceedings you have. We do not speak now about the civil proceedings because Mr. Dorin's case is criminal. Once you started that there is some accusations from that you may have committed crime, it starts that there will be a pre-trial investigation by a prosecutor. Even at this stage of the proceedings, you can already start to reprimand any violation of the convention which could be affect the outcome of the proceedings. That means you also, from the beginning, you have to be very careful and very attention what could be happen during the proceeding. It could be whatever, that the detention or the custody is not based on law, and during this, after a certain period or when this investigation is finished, the indictment has to be filed to the court, and from there it starts the normal legal avenue. Starts with the regional court, that's the first instance, going to a Supreme Court, that's the second instance, always based in each canton, and the last court will be the Swiss Supreme Court, Swiss Federal Supreme Court.
Can you tell us the situation with human rights protecting in Switzerland? What's the situation? You have a lot of complainings about this. Yes. On this.
If you see the statistics of Switzerland, it is perfect. In reality, and this is also related to the case of Mr. Dorin, it's desolated. Switzerland is, how can I say it, is really, or better to say, the judiciary machinery is hindering and foil the rights and freedoms of the convention. This means for me as a human rights lawyer that if I start to reprimand an allege a violation, the courts ignore it totally, or in the best case, they just consider it partly that the outcome will be in favor for Switzerland. And when you continue through all those instances, at the end, when you end up in the Federal Supreme Court, you can be aware that the court will, whatever the substantiation of your complaint or your appeal will be, they will declare it inadmissible. Okay? And this is very important for the further proceedings going to the European Court of Human Rights, because the court only accepts any application if you successfully passed the entire or the whole legal avenue of a country.
What are usual, let's say, human rights infringements in Switzerland?
The spectrum is, in general, it's of course private and family life for people who lived in Switzerland as a foreigner and who has to leave the country to be deported. Questions about family custody, yeah. And the next question, of course, which is the main part of the decisions and judgment of the court anyway, is a fair trial, Article 6, which has a lot of contents and a much influence as a minimal guarantee on a criminal case or also civil case. And another point would be Article 5, which is related to custody or detention, and Article 3, protection for inhuman or ill treatment, which could be a question if someone has bad conditions of detention, for example.
Now, let's talk about Mr. Dorin's case a little bit more. Yeah. He was faced with very unfair treatment while he was in custody. The conditions of his imprisonment were horrible.
Yes.
Can you tell us more about it?
I can just give you one example. When he was in his pre-trial detention, he was in a cell without air conditioning in summer, and the temperature went up to more than 40 degrees Celsius. And this is, in my eyes, and I think most of your audience and you will agree, this is really inhuman. Mm-hmm. But this was just one point why he was in detention, and that would be for me an infringement of Article 3 of the Convention, which exactly protects someone from such inhuman conditions. Mm-hmm. But unfortunately, when he was in detention, I was not his lawyer at this time.
When you talk about these articles, you are talking actually about European Convention of Human Rights.
Yes.
It's written in Article 6 and connection to Article 18 that is relevant for this case. What exactly is written in these articles? You said right on a fair trial, but what does it mean?
Yeah, a fair trial.
Reasonable time of a process.
Yeah. For example, reasonable time, fair trial in the meaning that the witnesses should be heard at the court, that you have a public hearing, that the court should be independent and impartiality. Mm-hmm. All those things are, as a general rule and minimal guarantee, in Article 6. Mm-hmm. But you can only have a fair trial if you, for example, have no political influence in a case or in a case. Sorry. And if you take this Article 6 in connection with Article 18, mm-hmm. as the next step, what we will do in his case, that we reprimand a political influence in this case, and a case which is politically motivated can never be a fair trial. Mm-hmm. It doesn't matter if it starts in the pre-trial, where we are right now, or if it ends up in the Federal Supreme Court, as once is there political influence on a case, you will never have a fair trial.
What exactly happened in Mr. Dorin's case? Why was he arrested, and was it a kind of political hunt? Yeah,
Mr. Dorin was arrested because he was alleged to be a drug dealer. That's why he had this search warrant, and he was, what I already said, in detention for about 2.5 months. For months he was in detention. And during this time, or better to say, short before he was arrested, he published his book about this genocide in Srebrenica. Mm. Yeah.
Genocide around Srebrenica.
Yeah. And there's another person in Switzerland who also have almost the same biography. Maybe you heard about Erich von Däniken. He is an author who wrote the book Chariots of the Gods. And when he published his book in the late 60s of last century, 68 I think, he also was arrested and was accused of forgery of documents and fraud. So what is the first thing what you think when you hear someone is a betrayer or forged documents? He's a liar. That's called framing. You see, it's just to defame the authors of such books. That shows, in my eyes, the political elements. As far as I know, Mr. von Däniken was acquitted decades later via a reopening of his criminal case, as far as I know. But anyway, in these days, 50 years ago, he was arrested and put in prison and sentenced for 3.5 years, where he had to stay 18 months. His book he wrote, Chariots of the God, also has a political content about the meaning of religion, how religion and the church and where we come from And if you take the content of the book of Mr. Dorin, I can see similarities. I see similarities.
Yeah. Mr. Dorin told me that he was actually accused for this because, let's say, a chief of Basel Police was married to so-called, let's say, Muslim woman from Bosnia that actually made an influence over her husband to arrest him.
Exactly.
She was against this kind of story Mr. Dorin wrote, which meant that there were also many victims on Serbian side, that there was a genocide against the Serbian population. 3,500 people were killed. So Mr. Dorin wrote the arguments about what Muslim forces did. She didn't like it, and then she made her husband accuse him for something and arrest him. Is that right?
That's how far I know of the case. I have to agree with that.
What happened to this police officer later?
Until today, nothing. Mr. Dorin gave me the mandate in February this year, and we are going to file criminal charges against the prosecutor and against maybe this woman. We have to decide that they have to be faced of misconduct or something like that.
What about the officer, her husband?
Yeah, the same.
Who was Swiss, the same.
Yeah.
Does he have this position still?
As far as I know, yes.
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 Okay. So what will happen in the future with Mr. Dorin's case?
Mr. Dorin's case, in about 2 weeks, we will have a hearing of a key witness with Mr. Dorin, and we will, of course, meet and challenge the allegations of this witness. And right after this, we are going to, what I already mentioned, reprimand the political influence of the case and start to push the prosecutor to forward the file, the indictment at the court, or to dismiss the case. Because the case is now already 5 years, and in the last 3 or 4 years, nothing happened at all. And it's also very conspicuous that once Mr. Dorin gave the mandate to me and I sent my power of attorney to the prosecutor, they started with this interrogation of this key witness. After more than 5 years, I see another infringement of the European Convention of Human Rights, because everyone has the right to have a decision or judgment within reasonable time. And I think 5 years without really omissions, no action at all from a prosecutor, for me, it's not understandable.
Okay, so as a summary of this case, we can say, I have it written here, that there were no implementation of a few articles of European Convention on Human Rights. Article 6 and connection to Article 18 that is relevant for this case, so right on fair trial, reasonable time of legal process and final judgment on legal basis for taking into custody or imprisonment and sufficient evidence and suspicion that a person could have committed a crime.
Yeah.
Is that right?
Yeah.
So what's the next step? Do you have any idea whether you'll suit the state of Switzerland because of all these infringements?
This is only possible if you, what I already said, pass the legal avenue. Yeah? And that means with a final decision, you have the key to open the door to the European Court of Human Rights. You cannot just go with just some exceptions which do not matter here. You cannot go directly to the court. Yeah.
Yeah, but legal system in Switzerland is, according to your words, is under great pressure of politicians.
Yes, indeed.
So do you expect a fair trial in this case?
No, I don't expect a fair trial.
What will happen to Mr. Dorin's property and, for example, savings? Everything is frozen at the moment. He does not have right to manage.
Right, it's seized for 5 years now. Yeah.
It's seized?
It's seized. And he has no option to sell his property or to get his savings, and this is exactly what makes this all very serious for him, and which makes this, again, like a hint that this could be just political motivated. Because I don't see any reason why the prosecutor does not make any progress in his case.
Okay, so you're trying to do this, but you think that you will be politically stopped, let's say. There will be a huge barricades in this process for you and Mr. Dorin. What is the solution? Can you hope to anything in this process?
The solution for this case or for Mr. Dorin is the public.
Public. So that can help you.
That can help for sure. That the people know about the case and that the people know how they work in Basel or in Switzerland, or it's not just about this question, about this case in general, that the people know about just, I don't want to say miscarriage of justice because that would be a wrong word. I really want to say arbitrary justice. I have to say this. Because as I said, there is no explanation. I see no reason why after 5 years there is no indictment, no dismissed case. And once he gave me the mandate and I sent my power of attorney, now they want to make an interrogation, a confrontation with the key witness 5 years after the arrest. So what do they...
So who's responsible for that? His previous lawyer or maybe the court? Or the prosecutor?
The prosecutor is the person who is in charge of the file, of the case. That means he has to investigate.
So he's responsible?
He's responsible in general. Because, as I said, of course, an attorney can force and give whatever, why you don't continue with these proceedings, why you don't summon this evidence, this witness, whatever. But in general, the head of the proceedings in a pre-trial level is the prosecutor.
Okay, you mentioned that there are so many human rights infringement cases in Switzerland.
I have a lot of them.
Yeah, we also have almost the same situation in Serbia, maybe much worse than that, for sure. It's also the judicial system is, let's say, corrupted, manipulated, politically manipulated, and it's under great influence of the government and the other executive bodies. Can you tell us about that criteria for, let's say, for the judges? How they are set as a judges
in Switzerland?
In Switzerland, is that a political way or what? Or they are just good professionals, so they become judges?
In Switzerland, there's one canton which is which is perfect. It's the canton of Fribourg. So this is an exception. But in general, in almost any other canton in Switzerland, the judges are elected for a term of maybe 5 or 6 years. Okay? These judges could be re-elected.
Re-elected.
So you have the first situation where there could be conscious or subconscious pressure on the judge because maybe he wants to be re-elected. But this is just one part. The main part is that if you want to be a judge and want to be elected, you have to be a member of a political party.
Really?
Yeah, it's almost.
It's not forbidden in Switzerland.
It's not forbidden. It's necessary. Without political party, you have almost no chance to become a judge. There are some exceptions from some persons who are not a member of the party, but this is just a few persons. And additional to that, and this is also the most important one, this connection to a political party remains during the whole time of service, because all those judges have to pay a so-called Mandatssteuer, mandate tax. That means they pay every year a certain amount of money to each party that they will be elected to be a judge. And this goes between 3,000 francs up to 20,000.
If they want to be re-elected?
Just in general, they pay this tax every year just because they are elected. And if they want to be re-elected, of course, it's a donation, but you can imagine what would happen if it just stopped to pay this mandate tax. This is, in my eyes, this is not independent.
That's how the courts work. What about the other institution? What is the real level of institutional corruption in Switzerland?
I cannot evaluate the level of corruption, but I can say, as far as I made my experience, I want to say it careful, from my experience after the last 2 or 3 years, it's not better than maybe some other countries.
Mm-hmm.
I want to say it carefully.
Mm-hmm. What does it mean? Does Switzerland have a very good marketing?
Mm-hmm. Marketing, yes.
Yeah, it's just marketing.
Mm-hmm.
Because here, when we think of Switzerland, we think of a very, first of all, peaceful, stable
Mm-hmm.
country, the place where there's a very good banking system, high level of democracy. So what you say now, what you are saying, it's very confusing to our public. They have never faced this kind of situation, this kind of information.
Mm-hmm.
So is it just a good marketing?
It's, you can say it's a good marketing, but the information are available in the internet. If you browse the internet and, for example, just enter the mandate tax, you will see that there is also some controversy about this.
Mm-hmm.
It's already started with the so-called judiciary, it's a very difficult word. Judiciary initiative that they has to change this system for a lifetime term for judges. You see, on a federal level. So there is already a debate about this. But this is not the point. The point is, if you take the Swiss lawyers, the Swiss judges, they have to pay this money until they quit with their profession as a judge. And there is a so-called Greco, that's something from the European, from the Council of Europe, that's that is a working group against corruption. They always reprimand this system of election and this mandate tax in regard of Switzerland. And this is a part of the Council of Europe. So
Mm-hmm.
you see, this is a topic. So why, if Switzerland has such a high standard of corruption, if this Greco, this group against
Mm-hmm.
corruption,
Mm-hmm.
reprimand this every year, and there is no progress on a political level to change this?
Mm-hmm.
I think this is a good point to think about. Why the political parties are not interested to change this, which is reprimanded by the Council of Europe.
So situation in legal system, when we talk about judiciary, could be improved only if judges would be elected for a lifetime.
Yeah, that would be maybe one step in the right direction, because a judge would not have the pressure from his political party. He was not be confronted to be maybe not elected. It's not just about political parties. Just imagine you have a very high or serious or political case,
Mm-hmm.
and then the public is watching you. You are just influenced and have to be aware, if I decide maybe not what the majority of the people would understand, but would be based on the law, which is valid at this
Mm-hmm.
situation, which is enforced. You also have, if it's subconscious, you have pressure.
Pressure.
You understand?
Mm-hmm. Mm-hmm.
And
when we talk about pressure, talking about it, was the public pressure, was the, if you have like a widespread public impact
mhm,
of people, of, I don't know, voters in Switzerland,
yes.
can it help? Are politicians a little bit frightened of that kind of responsibility they need to have towards people who
Mhm.
elected them?
Yeah, indeed. But the public, the majority, is almost the strength, because the people in a democracy should decide. Yeah, of course, it has to be a separation of power. That means that not the people will decide about a specific case, but at the end, the people decide which is the political direction of a country. What
Mhm.
is the organization of a country? Yeah, what is the Commonwealth in the general?
So that public pressure could be useful.
Yeah, of course.
Could be useful.
On some hand, on some hand, on one hand. On the other hand, it could also be misused
Mhm.
for any political interest.
So that's it. Now we have mentioned institutional corruption, and we have mentioned different situations with human rights protecting and legal system in Switzerland. Can you tell us a few more cases, examples you were in?
It's not necessary just to refer to my cases. If you check the recent decisions on judgments at the European Court of Human Rights, which are published in general Tuesdays and Thursdays, there are a lot of examples where already started that there are really not understandable decisions from the Federal Supreme Court. I just would like to refer in particular to a case which was published in April 18 last year. It's called Judicial contre Swiss. In this case, and this is what I said in the beginning, the Supreme Court of Bern and the Federal Supreme Court ignored a whole reprimand of a violation of the convention. And the court found in this case that this is a violation because that there was no decision, which was I don't know what the word can you
it's okay. We can
with grounds. A decision with grounds. It was not, and I experienced the same in my cases. If you write something which is not in favor of the courts, or even which goes more far than the Federal Supreme Court has defined the Convention for Switzerland in its own jurisdiction, they just ignore it, or they manipulate the substantiation to get a consideration which, and let's go back again to the political part, might be a political favor, on political interest.
Okay, let's talk about this kind of a relation between Swiss courts and Swiss judiciary and the European Court of Human Rights in Strasbourg. First of all, we have to mention that Switzerland has signed the convention in 1974. Is that
yes,
right?
This is right.
Actually, the convention was signed in 1950, but it took 24 years to sign it. But not all the additional protocols, which is very interesting also. Why those additional protocols? Why not all of the additional protocols are not signed? And why only the principal text of convention is mandatory for Swiss courts?
As long as a member state does not sign and ratify a protocol, then it's not getting valid for that member state. And this is not mandatory. Why the political decision is not to join that protocol or the other one, even Germany has signed a protocol and did not ratify it, this is nothing which is something negative, because it's honest. They do not want to join this additional right, but the root, the main convention, this is mandatory for every country, and every country is obliged to implement the jurisdiction of the European Court of Human Rights, because this is a minimal guarantee which is defined by the decision and judgments of the court.
You have already mentioned a few articles, Article 5, 6
exactly.
and 18.
And this is some sort of case law. That means if you just read one of the articles from the convention, it might be one paragraph, but it's just a general sentence or a term or an expression. And the court defines it by the court calls himself a living instrument, that it always starts to define the rights and freedoms of the convention on the actual political and society and situation.
All right. Why those additional protocols haven't been signed?
This I can't answer. I'm sorry. I have no idea. Might be something with political decision.
Because they wanted to keep the chance to actually implement this kind of political appreciation to the other people.
Well, this is just my own opinion, what I can give you for an answer right now. For example, there is the first protocol, additional protocol. And this first additional protocol has an Article 1, which guarantees protection of property. This right contains, aside not just the property, what we understand, what you own, what is your own belongings, it also contains social insurance. And this is a building, a house. So if, for example, just go back to the case of Mr. Dorin, it's just an example what the convention could mean for someone if someone could rely on those rights. his property is seized, so he has no right to use his property. And that could be an infringement of Article 1 of the first additional protocol if it would be enforced for Switzerland. You understand? But this exactly is not possible because they signed it but never ratified it.
Never ratified.
You see, so property is not protected.
In Switzerland?
It's protected by the Swiss constitution.
Okay.
But as I said, about my experience with the Swiss courts, and when we have a look on the case of Mr. Dorin, I have no idea if someone would just refer to the constitution of Switzerland if he would have success about the property. But in general, the protection of property based on the convention and with Article 1 of this additional protocol, it's not valid for Switzerland.
It's not valid. Okay, we understand that?
Yep.
Now, the key question here, because we have already set this conversation as the European Court of Human Rights infringements and manipulation happening in these courts. When and why did you start investigation on this issue?
It all started with, let me say, October 2016, when I first noticed that I had problems with the decisions, with the dispensation of justice at the courts. Because they started to write something which were not really related to the case, or they just ignored what I said with all the stuff that I had to refer, and I referred to the national legislation, I referred to the Swiss constitution by these days, and that's why I had the idea, okay, so let me just and only refer to the rights and freedoms of the convention, because there I have the court in Strasbourg, and I have the articles, and the decisions and judgments of the court, which I can show to the Swiss judiciary. Now I start to learn it. Yeah, wonderful. And I thought, okay, so they have no chance to manipulate this, because when I send them a decision, or better to say a judgment, which is binding for Switzerland, if Switzerland was the respondent state of this judgment, then they would take care of this. And I can tell you, and I could prove it with all the documents I have, it's not true. That's exactly what I said, that they maybe consider it partly or ignore it totally, and then you have no chance.
The important thing, the important question is the arguments. What are your arguments to think that there is manipulation of cases coming from Switzerland to the Strasbourg court? I hope we are going to see on this wall the Charter of European Court of Human Rights, so we can see those so-called steps.
Yes.
Once you apply to Strasbourg Court, what are the steps? Individual application first goes to single judge, and that's the place when they decide about admissibility or inadmissibility of the application. So that is the step, that first step is a very suspicious step for you, because you have faced the unfair situation about this. Can you explain us? So what are the arguments that this happens?
The very first step is what I already mentioned in the beginning, that you have to pass the legal avenue of the country. That means after a decision of the Swiss Federal Supreme Court, I could proceed within a time of 6 months. It will be reduced to 4 months if another protocol gets enforced, but at the moment it's 6 months or 4 months, whatever. And once you have the application filed or lodged with the court, it goes to a pre-examination. That means it's exactly a test, or it will be checked. Did someone obey the 6 months period to lodge the application? Did someone already exhausted the national domestic remedies? And at this point, I see a weak spot at the European Court of Human Rights. I already mentioned that the Swiss Federal Supreme Court ignores any reprimand, or they declare any reprimand any substantiation of a reprimand or alleged violation, they ignore it or only consider it partly, and do not reject it. Okay? Reject it. And declare it inadmissible in the domestic level. once you do not pass a decision, domestic remedies, the court will not deal with your application because you did not exhaust domestic remedies. And this is a point where you go in circle. For example, if you go to the European Court of Human Rights and you reprimand the courts, in particular the Federal Supreme Court of Switzerland, is not independent, lacks of independence and impartiality, because it ignored my substantiation and or only considered it partly and declared it inadmissible. The European Court of Human Rights, as far as I made experience in a couple of my cases, declares the application inadmissible because I did not exhaust domestic remedies. So I go in circles. And this is exactly the point where I start and have high suspicion that there might be also manipulation at the European Court of Human Rights. Mm-hmm. Because at the European Court of Human Rights, when you file an application, as I said, in this normal way, you finish that national legal avenue, you file your application, you have that pretest. If it's obviously manifestly ill-founded, or you really did not succeed with the national domestic remedies, it will be declared inadmissible with a single judge formation. I have no doubt that a lot of applications going to the court in Strasbourg are really inadmissible from the very beginning, because either there is no infringement of the convention or someone really did not obey the rules of each country to pass the domestic remedies. Okay, I don't have no doubt about this. Once you have passed this level that the pretest says, okay, there might be an infringement of the convention, it goes forward to the committee, which is found by 3 judges, or it goes to the chambers out of 7 judges. And they might again decide about the admissibility, as I said before, or made a decision on the merits, on the content of the application. And there might be a step going to the Grand Chamber, but this is just like an appeal, which is very rare and depends on specific situations. It's just these 3 steps are important just to understand the system of the court. And the weak spot is not on with the 3 judges or with the 7 judges, it's with a single judge. Mm-hmm. The single judge, and this is a regulation for the court, which makes sense, can never be the judge who is from the country of which the application is against. That means the Serbian judge could never be the single judge for applications against Serbia. The Swiss judge could never be responsible for single judge formations against Switzerland, and so on. Therefore, another judge from the court has to be in charge for this country. In the worst case, this judge do not even speak the language nor can read the letters. For example, me, I could never read an application against, for example, Georgia. I do not understand the language and not the letters. Understand? So therefore...
But somebody helps you in this case.
Exactly.
And that's the issue.
And this is the weak spot. Mm-hmm. Every country has a legal division at the court. And this legal division is with members
from domestic country.
Yes, because they
where
have
the application comes from.
They have the knowledge about the legal system. They have the knowledge about the legal avenue. They have the knowledge about just the rules about the court in Strasbourg, that is it admissible or inadmissible. And these people, or these persons decide at the end the case, in the worst case. Because there is, as far as I know, no translation, because they make a report on trust for the judge who is the single judge. So you see, there might be a weak spot. And if we go back about this political system in Switzerland and the judges and the Federal Supreme Court, I can no longer believe that all my applications are inadmissible if I can send to the court decisions or judgments from the Federal Supreme Court where they ignored and falsified my substantiation. Mm-hmm. And say, court, here it is obvious that this court is not neutral or independent and impartiality, because you see that falsified of my substantiation. But I have a few cases which passed this level and went into the proceedings, like third committee or judge or chamber decision, judgment. Sorry, but once you reprimand anything with independence and impartiality of Swiss judges, you never get further than this single judge formation. I do not want to accuse the single judge. I have a suspicion against 2 other people who are working for Switzerland, and I could during my research in the internet, I could found these names, and they have some very interesting biographies.
Mm-hmm. Oliver, once you mentioned the structure and organization of Strasbourg Court and the way of the processing the application, once you mentioned that there could be a weak spot for corruption at this first level, single judge level, where they decide about inadmissibility or admissibility. You also mentioned that this legal division helps to a judge.
Yes.
But sometimes, or more often than sometimes, they actually cover the interest of the country where the application comes from.
Yes.
So, what are the names of members of Swiss legal division here? You know these names. You know these people that actually stop these kind of cases in Strasbourg Court.
Yes. First of all, I have to emphasize that also for these people in the legal division they have to adhere to strict independence and impartiality. It's the same regulations like for judges. But during my investigations with all my experiences that admissibility and inadmissible decisions, I already told you about this, that I was also successful with some cases. But as soon as I start to reprimand the independence of Swiss courts, I always end up with 2 persons. Therefore, I only know partly who is at least the members of this legal division. But 2 persons I had to find out because I took notice of these persons, because every time when I had an inadmissible decision, it was with the participation of these 2 persons.
Who are they?
The first person is, I found it out with the initials of these letters where they inform you that this decision, that the application was declared inadmissible. There are initials with 3 letters. And the first initial was a D, A, and R, which stands for Daniel Ritiker. And the second initial was A, M, and C, which stands for Alexander Misic. These 2 persons have a very interesting biography. May I introduce what, as far as I could find out in the internet? The first person, Daniel Ritiker, is working with in the court since 2003.
Strasbourg Court.
In Strasbourg Court. If you just take a judge has a limited term of 9 years without the option of re-election. So you see, he can be even longer at the court than the judges itself. This Daniel Ritiker is a lecturer in a couple of events from many associations in Switzerland. One I found is, for example, a Basel Peace Office, which even receives money from the Basel government, 50,000 francs. You can find it in the internet. And even the coat of arms of the Canton Basel-Stadt is on some flyers from this Basel Peace Office. But this Daniel Ritiker even have an own association in Switzerland. It's savna.org. That's the website of it. It's an association against nuclear weapons, which is at least a good topic, a good content of this association. But if you check this association, it's based or located in Winterthur in Switzerland. But if you go on the contact site, you find a mobile number from France. So why do I have an association in Switzerland if my contact details or contact number is a French number? That might be a connection to Switzerland for whatever reason. I don't know it. I just see it's very suspicious, as I already said. And when he's a lecturer, he also has contacts to Swiss politicians from the national parliament. You can all find in the internet when he appears as a lecturer, then you find someone from the parliament, someone from Basel, and so on, and so on. So therefore, I do have another understanding of independence and impartiality. That's my understanding. For me, there's a close relation to exactly the country where he is to decide the applications. But the second person is much more interesting. The second person, this Alexander Misic, is working with the court in the court since 1st of January 2018. Do you know where he worked before?
Tell me, please.
At the Swiss Federal Supreme Court. And do you know exactly where he worked? Exactly in that department where I had the most problems, where they ignored and falsified my argumentation with the reprimands of the violations against the Convention.
So what do you think, what's his real influence over decisions on this first level in Strasbourg court?
The influence could be, for example, that they explain the judge, the single judge, that person did not non-exhausted all the domestic remedies because of whatever reason, this and that and so on. I mentioned that case, Ucho contra Swiss, in the beginning, if you remember, where I said Ucho contra Swiss, where they ignored, like in my cases, I have no relation to this case, but where they ignored it. In this case, the representative of the Swiss government told the court that the applicant, in this case Ucho contra Swiss, did not exhausted the domestic remedies. You see, we always go back to this argumentation from Switzerland by stresses and said you can have a revision because the Supreme Court ignored that reprimand. That is written in the decision. You can read it in the internet. The own jurisdiction of the Federal Supreme Court says that you can never have a revision even if the court ignores a complete or oversees a complete reprimand. Mm-hmm. So you see, from the very beginning, this argumentation of the Swiss government is wrong. It would never work that you could have a revision in such circumstances. Yeah, it's jurisdiction of the Federal Supreme Court in Switzerland. And if I take all those elements, I could imagine that they maybe give one or another point, or in some situations, a judge incomplete or maybe even false information that the single judge thinks, who has no knowledge about the law system of the country he has to decide, that someone has non-exhausted the domestic remedies. And in reality, that person would have exhausted domestic remedies. And that's what I said, we go in circles with this, because when I reprimand that the court ignored my reprimand and declared it based on this falsified argumentation, declared it inadmissible, and I go to the court in Strasbourg and I receive that this is inadmissible because I did not exhaust the domestic remedies, it all goes back to these two persons. Mm-hmm. Because they are always mentioned on the letters when you receive when it's inadmissible. I have a decision which was published.
Which means they do not work for Strasbourg court, they work for their government, actually their domestic judiciary.
Yeah, that's what I would have to...
That's your conclusion.
My conclusion about this, exactly. This is what I have to, this suspicion I have. Because you cannot understand how it is possible if a court, you can prove it, that the court ignores what I write, like in this Ucho contra Swiss. But then it is declared inadmissible because I did not exhaust the domestic remedy. So how can I exhaust the domestic remedy of a political court if it ignores and falsifies my argumentation, my substantiation of my appeal? And it's impossible. I have no chance. No one has a chance to go to the European Court of Human Rights if you have this combination.
But you had some success.
Yes.
Some cases had gone to committee, three judges committee. What happened then?
These cases were before the 1st of January 2018. There was not this combination. It was another combination of the people, of the person who processed it on this pre-level.
So you want to say, since Alexander Misic
definitely
is here in Strasbourg court, there's nothing happening anymore.
Yeah, definitely. Mm-hmm. This is what I have. This is what I can prove. Since that day, whatever I go there, it's all inadmissible. But I have another very good example to say that there's reasonable suspicion that there could be fraud or even manipulation in favor for Switzerland. As I said, I have a decision from this recent decision from Thursday this week, which was published, and it was in one of my cases with the client CD, that is not his real name because he had anonymity, versus Switzerland. This case is from 2017, and we first had an interim measure. That means that Switzerland was denied to deport my client to his home country. Mm-hmm. That's why I already passed this single judge formation, because it directly goes to a judge. You see, that's again, these proceedings were successful because I did not go the standard way. But this is not the point. In these proceedings, you get the written observations of the government. You can reply on that. Then you maybe get the second written observation, like in this case from the government. And then I received a letter. It was the 28th of March 2018, where the court informed me that this proceedings is finished so far at this position. It was just for my information, and that I should not answer on this last mailing from the 28th of March.
But you did it.
I did it on the 3rd, on 4th of April, because I found new evidence which could prove that what the government tried to tell the court, that my clients did not exhaust the domestic remedies, that this was ineffective. Yeah, it would never work what the government offered to the court in Strasbourg. I just keep in mind that Uche contre Swiss, yeah, with this revision. So I sent 2 letters to the court on the 3rd of April and on the 4th of April, which were acknowledged by the court that they received it, that they accepted it, and that they would examine it. And it was forwarded to the government that they could send another written observation on the 30th of April. But when I read the decision from last Thursday, there is no single word
of those new evidence.
The content of these 2 letters. And even worse, in this decision is written that my client, and at the end me as his lawyer, did not provide or did not give any arguments about this non-exhausting of domestic remedies. And this is untrue. And I can challenge everyone who said about this, about this allegation. Everyone can challenge me. I can prove it with all the facts from the case and all the other letters I have. I brought some examples that people can see what has happened in these proceedings. Unfortunately, it's in French. That was the letters from the 28th of March. Could we bring it on the screen?
Yeah.
The letter already done? Okay. The letters, I said, there are 3 letters. And therefore, I have suspicion that there's manipulation, because there are 2 ways. The first way is this inadmissible decision by the committee was pronounced by 3 judges. The first judge is the Swiss judge, Helen Keller. The second judge is the judge from Portugal, Albuquerque is his name. Albuquerque, I don't know how to pronounce. He's from Portugal. And the second judge is from Spain, Elusegoy. I don't know how to pronounce it. These 3 judges are mentioned in this decision that they made unanimously the decision that this is inadmissible because my client did not exhaust the domestic remedies. There are 2 options now. The first option is the 3 judges, the Portuguese judge, the French judge, the Spanish judge, and the Swiss judge, read these letters and ignored it to give this false consideration. Or the second option is they never have seen these 2 letters because, as I said, on the end of March, before my mailing, the court told don't answer on this letter anymore. So they maybe took it out, and the 3 judges have never seen this.
But in that case, why did they tell you that they will reconsider?
Yeah, this is an option what I could have, but I can tell you I also contacted fraud alert of the European Court of Human Rights. There's a department which is in charge. If you have reasonable suspicion about fraud at the court, you are encouraged to send them the letter, and you have to make extra. You have to mark it with private on the letter. You have to send it that they get information, and it happened nothing. They refused to answer on these letters. They sent me, really, I have to say it, absurd answers, where they just explained to me that this legal division is not making any decisions on cases, but they assist the judges on the adjudication. This is what I know and what I wrote in my letters to Fraud Alert.
So just one more thing, we need to be clear about that. Okay, you said that the members of legal division of each country, they have influence in a first level of decision, so which is a single judge level.
Yes.
Do they have any influence over a committee where 3 judges
They are also joining the proceedings, like whatever the redigation of a decision. Yeah, the grounds from they write the decisions. This is what they have to do to participate. How much they participate. This is what I can't find out in the internet, and I have not been in the court itself inside, but they participate and they are responsible for the files. So who never knows.
They are responsible for files.
Mm?
So you suspect actually that they did something wrong about this.
I don't want to believe that all 3 judges from 3 different countries make such a decision in a case where my client has to fear inhuman or ill treatment or even worse, illegal killing when he will be sent back in his home country. That's why there was a real risk. That's why there was this interim measure in these proceedings in the very beginning. I don't want to have to believe this. Therefore, I, for myself, would like to believe that someone maybe manipulated the case. I don't know it, but as far as I could show and over these letters, this all does not fit together anymore. And if you take the biographies of the other 2 persons, for me it's the only conclusion there must be something irregular. Like I want to say it very carefully.
Okay, please could you tell us something more about the principles of election of those judges? First of all, judges in European Court of Human Rights in Strasbourg, and then principles of election of the members of legal divisions. What is the way they are elected?
That's a very good question.
On what basis? What arguments and criteria?
Good questions. The judges for the European Court of Human Rights are 47, equal to the members of the Council of Europe. The Council of Europe has a parliamentary assembly, which is the parliamentarians of any member state are meeting 4 or 5 times a year. I think 4 times a year. This parliamentary assembly elects the judges for the European Court of Human Rights. Every member state has the right to present or to offer a judge of his choice, where he would say, this judge is perfect, we would like to have this judge for us, for our country, for the next 9 years as a representative from our country, but they have no relation to their country. They are just for the country inside the court. Okay? For example, at the moment, the Serbian judge is Branko Lubarda, for Germany is Angelika Nussberger, and so on and so on. They are elected for a term of 9 years, without the possibility of re-election. That was possible until the beginning of 2010, but in the now legislation for the court, they are only elected once. To be elected, you do not only need the majority at the parliamentary assembly. There is also some sort of, I call it, it's research or about that. Who are you? What is your reputation? Do you have good social standing?
Are you eligible for this position?
Eligible for this political position. Thanks a lot. Exactly. And this all is not for the members of the legal division. They can stay, what I already say, for decades at the court, like this Dr. Daniel Ritika since 2003. They're not elected. If you take it strictly, they are even members of the Council of Europe, working inside the European Court of Human Rights. So you see, they have, what I said, adhered to strict regulations of independence and impartiality. I don't know what I have to understand under this term. If I would have said if someone is working.
So what you are saying, they are members of a legislative body, and at the same time they are part or members of this judicial body.
No, they are just employees of the Council of Europe.
Oh,
okay.
Employees.
They're employees of the Council of Europe.
They are not members.
They are totally belong to the court.
Mm-hmm.
Yeah? Okay, sorry that I didn't express myself properly. And this is exactly what I see as a weak spot. You have on one hand strict regulation for judges, and they have to be good reputation, eligible for this. And on the other hand, you have a legal division with persons who can sit there for years without any limitation.
No clear criteria for them.
No criteria, exactly.
Mm-hmm. Right, this is about the principles of electing judges. But what about the decisions of European Court of Human Rights? For example, there are also many countries, not just Switzerland or Serbia. I don't know what you really know about our legal system, but and rule of law and such things is quite endangered here for decades, let's say like that. But anyway, talking about these applications in European Court of Human Rights, what's the effect of the decisions of Strasbourg Court over the countries, legislative, not legislative, but judiciary?
Yeah. First of all, if the court delivers a judgment, it binds only the country which was a respondent state in this proceeding. Therefore, if Serbia is a respondent state and there's a judgment against Serbia, Serbia is the only state which is binded by this decision. Okay, it's only binding for Serbia, and this country is responsible or has the obligation to implement the decision. It's the judgment itself.
Is it obliged?
Yes.
The country.
Yeah, it has to implement whatever this means. It can be to reopen the proceedings. It can be even to change the law. It depends. To pay a punitive damage,
penalty.
Yep, whatever it could be, but it has to implement the judgment.
So the judgment has to be implemented.
Yes.
If the Strasbourg court decided in favor of the applicant.
Yes, but as I already said, the court itself has a case law which defines the convention or the content of each article. And this automatically means or contains that every member state has to obey the jurisdiction of the court and the decision or judgments to understand how far or what is exactly the content of each article. Therefore, also a decision or judgment against another state might have an influence for another state with the
it's so-called case law.
Yeah, case law, exactly.
Did you have any cases based on this case law? So it was implemented in that case.
In my client?
Yeah, your clients, or maybe you know about such cases.
Well, there's one case which I can still remember. It was one client. He's from China, and he was accused about the minor infringement. It's not the topic about this accusation. And he was acquitted on the first instance, where the first instance heard the witnesses. In the second instance, at the Supreme Court of the canton of Bern, they did not rehear the witness, but changed the acquittal to a sentence. And this has happened 20, 30 times already in the jurisdiction of the Convention of the European Court of Human Rights, that this is an infringement of a fair trial principle. Because if a court changes an acquittal to a judgment and does not rehear the key witnesses, this infringes or hinders the applicant in his rights of a proper defense. You understand? Yeah? And this was Moldova, Italy. There are a lot of decisions and judgments from the court in other cases. And guess what has happened, as I mentioned this at the Supreme Court of Switzerland Supreme Court, and mentioned all those judgments. Guess what has happened? I did not exhaust it. Yeah, because I only would have mentioned the article of the convention, which is not true. I mentioned all those judgments in my grounds of appeal, and it was ignored, and it was just written that I did not make a proper substantiation, and they made an inadmissible, and at the court in Strasbourg, guess what was happened? Inadmissible because of non-exhausting of
domestic.
Yeah, that was one of the decisions where I really started to figure out and to research and to investigate how is this possible. And that's why I started to find out about the names and about the initials and the letters. That was one of the cases which was a real shock for me, that this is possible. That this could be happen at the European Court of Human Rights. In my eyes, I cannot understand. You go to a court, to a highest court in a country, you mention the article of the convention, you mention and cited all those judgments. It was such a line of decisions and judgments of the court. And then you just get back the information that you should not have made a right substantiation of your appeal. You mention this at the court and say, court, in the European Court of Human Rights, saying, here, I did all in my documents, it's all documented, I made all the reprimand, I mentioned all the judgments, and they just ignored it. And what has happened? It was inadmissible.
So what's the point? What's the point of the court if these things happen? So you say that if Strasbourg Court, European Court of Human Rights, if it does the right thing or righteous things, it could be a great, let's say, pressure or maybe effect on over the domestic legal system of each country.
Definitely.
If they do it.
Yes, definitely.
Or if they did it, maybe it's better. If they did it, it would be much better for everybody. Okay, so let's go back to the beginning now. Yeah. What about Dorin's case?
Yes.
What about Dorin's case? What do you expect?
Yes. I really have to express my deepest concern that if this problem at the court will not be solved, that he will really get problem in his litigation inside Switzerland, because who should criticize, who should judge about this? If he has to experience or have the consequences of all the other cases. I mean, I said it's all not just with me. There are other cases in the internet where they also make this non-exhausting. It's the internet, this website of the court, that HUDOC, it's the database. It's full of such decisions where you see non-exhausting domestic remedies, non-exhausting domestic remedies. It's like a row. And I really worried, and I really fear that Mr. Dorin will have a lot of, I say it, hassle in his proceedings and further proceedings to get his right. As I said, political motivated.
So what does it mean if they have so many cases which had faced inadmissibility?
Of non-exhausting domestic remedies. Okay. That's a very important detail.
Okay. Does it mean that there is a huge impact of national countries represented in Strasbourg Court, a great impact over these decisions on a first level?
This has a big impact for Switzerland because they can show perfect statistics.
What about the other countries?
I have no idea if other countries have the same like this. I cannot say reasonable suspicion that other countries do the same. I have no idea. I don't want to say something wrong because I only have the experience with Switzerland. What I can say and what is a fact, this Daniel Rieteker is also responsible for Austria. This is what I can say. I found letters, same inadmissible letters in the internet as a PDF scan. Someone put it into the internet because he was disappointed or upset, whatever. And there I found exactly the same initial DAR. And this means Daniel Rieteker is also responsible for Austria. And there is a photo in the internet where Mr. Rieteker is at the Department of Justice in Austria. But this does not mean that that he does something wrong for Austria. I don't want to say that. I just want to say this is a fact. He's also in some relation with Austria. This is Daniel Rieteker.
So you have this kind of suspicion. Okay. Do you have colleagues from the other countries telling you that they face the same issue as you do?
I have a contact with a lawyer from Lithuania because he contacted me. He read in the internet about my my actions inside the Swiss law system as judiciary.
Judicial.
That's a very bad word. I don't think I will never learn
like
it. Exactly. No, seriously. And he's from Lithuania, and we had a telephone conversation. And he said in his country, the European Court of Human Rights has a very good standing, also with the decisions, and he never heard a complaint or something about as similar to that what I have experienced. In Germany, the same. There's also a good picture and a good reputation about the European Court of Human Rights. In Switzerland, if you check the internet, you find a lot of people complaining about the court, that they had so good application and they were rejected.
So this might be a unique case.
Yes.
Concerning Switzerland.
Yes. As I said, there are a lot of people complaining. By the all unique cases, they never had such that they could compare it with anything else. Me as a lawyer, I have a lot of examples. Yeah, I see what I do in my proceedings, and my clients still with me because they see the same. They never ran away. The opposite. They gave me my release of my obligation to preserve secrecy. That even I can show the files, I can show the documentation, and all the other stuff. And I just can say there's something strange in regard to Switzerland.
So your first suspicion is on this legal division.
They are doing
over there.
Yeah. This is
so generally, the let's say common picture of European Court for Human Rights is that they do a good job.
Yes.
Your colleagues around Europe, from the other European countries. Heard, But your suspicion is that something is wrong in legal division, and that Swiss court, Swiss legal system actually influences a lot these Strasbourg decisions. I was asking you about further steps concerning Dorin's case and this Strasbourg manipulation. Who are you going to inform about this? Of course, you are now in this show, you are explaining to people what's really going on. But is there any further step concerning this issue about Strasbourg manipulation and corruption?
Yeah, Mr. Dorin and I, we will continue with these proceedings like we had already our strategy. But we hope that we, with this interview today, start a public debate about the situation in regard to this legal division.
And this public debate could help.
I hope that
could be a good warning.
The awareness about the situation, that there might be a weak spot, which I already mentioned. Maybe there are people coming and say, I have the same problem with my case. It was happened the same when I had my decision at the Supreme Court in Switzerland. It was also declared inadmissible. Maybe people from other countries will take note about this and will say, in my country it's the same. Because people usually get groups of interest. Yeah, they may be found in our association or something like that, where they always have the same victim of the judicial whatever.
Whatever. So you think that it could make a kind of changing in politics of Switzerland, in political life. Maybe that political will be changed. Maybe they will not influence judicial system that much in that kind of widespread action.
Yeah, this is a question which is essential. It's not just about the single case. It's not about me or about Mr. Dorin. It's a question about the basics. Do we want such a possibility that just something could cause a suspicion? Or do we want to change something that there's not even, that there's something could be made irregular, that you just think about corruption or think about manipulation? And this needs an awareness. And the politicians, maybe, if they're interested to change it, this is what I cannot, and especially the people. Because the people have the vote in a democracy. And if you can find majorities, it will be changed.
How could citizens of Switzerland feel about this when they hear these stories?
I'm pretty sure they won't be happy. Pretty sure. And I expect that I will have more personal consequences than before.
More?
I expect.
What does it mean? What consequences have you been faced with so far?
So far, I encountered mobbing.
Mobbing?
Mobbing, as I said, they ignored it, they ruined my name, my reputation, they tried to ruin my career, they tried to destroy my business, and so on. This is what is typical for anyone who is a dissident.
You have an independent private lawyer's office in Basel?
I have, in Bern.
In Bern?
Yeah,
Mm-hmm.
I do have. And I fear after this that it may, or maybe I also will have problems with the European Court of Human Rights, that they will reject me and no longer allow me to represent clients at the European Court of Human Rights. But someone has to speak about such problems. Yeah? If everyone stays silent, there will never be a change. If there was something happened to me, I have no idea, but if we go back to this fraud alert, this department from the European Court of Human Rights, there is a rule from the Council of Europe which guarantees me anonymity and protection for any retaliation. And what I already said, my name was disclosed to exactly the people from the legal division, and shortly after I sent my letters to Fraud Alert, I have this decision which I mentioned before from my client, which was published on Thursday, which was deliberated on the 16th of September, exactly when I started with my letters. So what do you have to think now about this decision, which have these irregularities about the file, what I said? What do you have to think about my future and the European Court of Human Rights? But this may be a topic for another interview in the future. Who knows?
We'll see. We expect you in this studio, maybe in 1 or 2 years period. So you can share a new experience.
But I hope more positive.
I hope a lot of viewers will see this interview so they can face this information maybe for the first time. Maybe they do not know about any of this, you said.
That's what I guess.
Thanks.
Thank you very much.
Thanks for your participation. Thank you for your bravery to be here.
Thanks a lot.
You must be very brave.
Thanks.
Is that a risk for your career?
What's that?
This is a risk for your career too.
Oh, I know, but which career? It's already ruined. It's already ruined. I have nothing to lose anymore. I have to say it exactly how it is.
Okay. If you could please stay with us, because we have a person from Switzerland who was faced with the human rights infringement. His name is Marcus. He's going to join us here in a studio, and he's going to tell his story in short, of course. So he's going to be a kind of support to this story you just told us. Now I want to represent you Mr. Marcus Omlin. Marcus Omlin is a client of Mr. Oliver Lieke. Oliver Lieke was a lawyer. You were able to listen to his story in a previous part of this show. Oliver Lieke is a defender of Marcus Omlin at second instance, Supreme Court of Basel-Stadt. Now it's interesting to hear this story. This is another story, this is another process we are mentioning this evening. And I would like to ask Mr. Marcus Omlin to tell us something about his case. First of all, thanks for being here. Thanks for trying to be honest about your case and trying to represent your case to the audience. I hope it won't be so harmful for you, but let's say that it is very interesting to hear about your case and about the kind of infringement you have been faced with for 3 years so far.
Yes, it was 2016, and in this year, after the divorce of my wife, I was accused by my wife and a witness by threatened my family, and they told the police that I should make the statement that I want to buy a weapon and kill the whole family.
So wife, her lover, and 4 children. Is that right?
Yeah, exactly. That's true. And the problem was that there are many circumstances in this case which are, for me it's very suspicious how I can get sentenced because I didn't do it. The problem was that the court didn't hear the witnesses, and after it was finished, the judge in Basel come and then they sentencing me, but they never hear the witnesses, and I cannot believe it. How can I'm sentenced to pay a fine, and they didn't hear the witnesses, and that's another very interesting point of my case.
Marcus, what are the evidence that you had and the court or the judge didn't want to take into consideration while your case was on a first level?
I want to make the statement in German, but es war in der Tat so, ich wurde beschuldigt, dass ich eine Waffe kaufen wollte und damit die gesamte Familie umbringen wollte. Als dieser Belastungszeuge zu der Polizei gegangen ist und dort seine Aussage gemacht hat er mit keinem Wort erwähnt, dass ich diese Waffe an einem bestimmten Datum kaufen wollte, sondern es wurde einfach, der Polizist hat aufgeschrieben, dass es an diesem Tag gewesen sein muss. Der Belastungszeuge hat dies jedoch niemals gesagt. Es ist jedenfalls in keinem Protokoll so explizit aufgeschrieben worden, dass ich in der Tat dieses an diesem Tag gesagt haben soll. Es ist quasi in der Fantasie von dem Polizisten entstanden, dass ich mir an diesem Tag eine Waffe hätte kaufen sollen. Bei der Gerichtsverhandlung ist es so gewesen, es wurde abgelehnt, Zeugen entsprechend zu interviewen, weil es gab noch eine weitere Zeugin, nämlich meine Ehefrau, die von diesem Zeugen in meinen Augen beeinflusst worden ist. Aber es hat in der Tat ausgereicht, weil die Richterin hat wahrscheinlich mehr an meine Schuld geglaubt als an meine Unschuld. Und deswegen bin ich am Ende verurteilt worden wegen etwas, was ich nicht gemacht haben kann. Weil an dem Zeitpunkt, wo ich diese Ankündigung ausgesprochen haben soll, bin ich nachweislich in Italien gewesen. Allerdings wurden diese Beweise komplett ignoriert und wurden nicht zur Sprache gebracht. Für mich hat man Folgendes gemacht, man hat diese Entlastungsbeweise unter den Tisch fallen lassen, um mich verurteilen zu können.
Okay, if you say it in English, what are the evidence? Because of the public watching this in English, you have the evidence, actually you had the evidence, and you told about them to your lawyer. He didn't react properly, and then for the second instance, after you've been claimed as guilty in a first instance court, you have changed your lawyer. Now your lawyer is Mr. Oliver Lieke, and you are trying to show them the same evidence you already had before, but now you want to present them to the court. What are these evidence, please?
Diese Beweise sind dermaßen, dass ich in der Tat diese Tat nicht begangen haben kann, weil ich zu dem Zeitpunkt in Italien gewesen bin. Das wurde erstinstanzlich wurde das nicht festgestellt und es wurden auch, wie gesagt, mehrere Zeugen überhaupt nicht durch den Richter befragt. In meinen Augen liegen hier schwerwiegende Verfahrensfehler vor, wo man allerdings sagen muss, scheinbar gehören ja diese Verfahrensfehler zum Standard von gerichtlichen Verfahren in Basel. Und damit bin ich als ehemaliger Bürger von Basel-Stadt nicht einverstanden.
Well, Marcus, unfortunately these things happen. I hope you'll succeed to prove that you were not guilty in this process. I hope that Mr. Oliver Lieke will be successful on a second level, second instance court, Supreme Court of Basel-Stadt, if I understood well. This was Marcus Omlin, and he told you his story, what's really happening in Swiss judiciary. Is this a lonely case, or this is a very usual case? We'll see in the future. Thanks for watching. Thank you, Marcus, for being opened for me and for the public to share your experience with us. Thanks for watching once again, and think about it. I hope this is only the first show who's proving that something is wrong in legal system, in our courts, with our judges. We should change them if they are not doing the righteous things. Don't you think so? Thanks again for watching.